Hello everybody, good evening. Martin Salvo here with an emergency broadcast to talk about the recently announced changes to the partner visa framework. As we now know, that's come through with the recent budget announcement. I just want to really quickly say, really at the beginning, just to kind of frame what I'm going to be talking about tonight, is I don't want anyone to panic into thinking that they need to be making decisions right away. Okay, I'll cover what the changes are, or the proposed changes are, what we understand in terms of what those requirements will be in future, and I suppose an estimated time frame of when these things will come into effect. So I'll just quickly get that out of the way because I know that's a concern for most of you probably watching tonight or even watching the replay, is that you're probably worried that things are going to change overnight and you're not going to have a chance to get your application in, or worse yet, you're going to rush to submit your partner visa hoping to beat these changes, okay? And anyone who's ever watched me talk about partner visa criteria and the process of preparing a partner visa and being organized in advance knows that one of the main things I say is don't rush into applying for a partner visa and get your ducks in a row, okay? And that's something I'll also cover towards the rest of tonight's stream. I'll give everyone a chance just to join. Not unsurprisingly, we have, I suppose, a record attendance for a weekly Q&A. Just so that everyone knows, I do this every week. Just so happens not every week we have dramatic government announcements relating to partner visa criteria that will affect most people in the future. So it's not surprising to see a lot of you here tonight. But hopefully you can all walk away with clarity and confidence and peace of mind that things aren't going to be as bad as what perhaps you feel that they might be, or maybe where you've read somewhere else, okay? So look guys, what I'll do is I'll get straight into the slides. There's a lot to cover, and I just want to get into the good stuff. So firstly, I do want to say, please take a deep breath, okay? Everything is going to be okay. Now, when I suppose news started to come out that there were these little partner visa changes in the budget, partner visa couples probably looked a bit like that meme, right? A bit of panic, a bit of fear, a bit of confusion and uncertainty, a bit of frustration. So all those emotions were probably coming out of you and your partner when you started to learn about these changes. And like I said, hopefully, this presentation and tonight's Q&A will help alleviate a lot of those stress-related emotions. So if that's you, that's okay, totally understandable. I can tell you that was us as professionals for a very brief period of time, and then once we started looking into things a little bit more carefully and a little bit more information and clarification from the government started to come through today, we're finding that it's not as dramatic as what it seemed initially, okay? So let's start with what we know. Okay, the 2020-21 financial year budget announced by the Australian government, includes intentions. It lists and outlines intentions to make certain changes to the Australian partner visa framework. Okay, now let's look at exactly what that means. What are the changes? What's been proposed? Now, I'm going to break this down into good news, not so good news, and bad news. Okay, so we'll start with the good news, because I want to give you guys some good news immediately. And the good news is that they're increasing the allocation of partner visa places in this program year. So the program year means up until 30th of June 2021. So we're already in, or currently in, the 2020-21 program year. And from what we understand, they're going to increase the allocation or the amount of partner visas that they will approve this program year. Now, in terms of the practical effect, or what we would expect the practical effect of that to be, is that we could start to see a reduction in processing times for partner visas as they now start to be prioritized. And now that the Department of Home Affairs will start to align its priorities with the Australian government, given the budget announcements and their intention to increase the amount of approvals this financial year for partner visas specifically. So good news, okay? Now that I would say is most relevant to couples that have already submitted applications. and that are pending with the department or pending with an offshore consulate or embassy. I would say that primarily, onshore A20 applicants are probably going to be the most positively affected by this, given that they're not impacted by COVID because they're currently in the country. But I would also expect offshore 309s to be processed faster than before. Just understanding though that couples that are approved, their offshore 309 still need to deal with travel exemption, not travel exemption, but in order of applying for flights and obtaining flights to enter the country once their 309 is approved, and then dealing with quarantine requirements once they enter the country. So there's still some practical limitations even if you get your 309 approved from offshore, but nonetheless 309 and 820 applicants I would say are probably going to be the primary beneficiaries of these, this increase in allocation of approvals this financial year. Now, I suppose the other positive thing that's come out of the budget announcement is that in situations where the partner, the sponsor, lives in a regional area, we understand that those cases are going to be prioritized this program year, this financial year. What we don't know specifically just yet is exactly what's going to be deemed as regional for the purpose of this type of assessment. Throughout migration law, Australian migration law, Australian migration regulations, and definitions are given in terms of what constitutes as regional for different visa types and different purposes. We don't know specifically what they're going to classify as regional for the purpose of prioritizing a partner visa. However, we can, I suppose, look at other areas of immigration law where they do define regional or give some definition of what constitutes as regional. And generally speaking, we find that anywhere other than Sydney, Melbourne, or Brisbane tends to be considered regional to some degree, okay? And that's in line with the broader government objective to push people away from those major capital cities and to rural or regional areas, okay? So we can assume, and we are speculating to some degree, but let's say it's an educated assumption, that if the Australian permanent resident or citizen partner lives in an area other than Sydney, Melbourne, or Brisbane, that those applications are pending with the department or an offshore consulate, that those cases might be prioritized. What exactly that requires to obtain prioritization of your application remains to be seen. It might be worth contacting the department, confirming, once I suppose we understand the specifics around how this is going to work, contacting the department or the consul or embassy that's assessing the application, providing confirmation and evidence of the sponsor living in that regional area with a bit of a summarized cover letter or legal submission if you're going through an agency or a law firm like ourselves. I suppose bringing the case officer's attention and the consulate's attention to the fact that the Australian sponsor lives in a regional area in that application, might be enough to get the application prioritized based on what we've heard, okay? We don't know specifically what that looks like just yet, but that's my assumption on how things might play out in terms of getting prioritization. I don't think necessarily the Australian government's going to, or the department is going to just pick out the cases where the sponsor is living regionally. I think it's going to be, or the onus is going to be on the applicants and the partner to bring that fact to the attention of a case officer. So be proactive in telling the department, telling the consulate or embassy that the sponsor lives in a regional area, provide evidence that they live in that regional area. That could be things like a mortgage rental contracts, any documentation that proves where that sponsor lives, and forwarding that to the department or the consul or embassy might be what's required to get prioritization in that scenario. Now the good news okay, the kind of good news, because unfortunately, it's a bit of a sweet and sour bit of news. Now, specifically, what we understand is that prospective marriage visa holders, okay, that have been caught really by COVID and the travel exemptions and the border, being closed, that have been unable or are unable or are going to be unable to enter the country before that visa expires, will be eligible for a refund of that visa application fee. Now, we all know that the cost to apply for a prospective marriage visa is, $7,715 at the moment. and most likely was for most that are waiting for their prospective marriage visa, or even the ones that have been approved. So we understand that those caught by COVID and stuck overseas and are unable to enter, with the pathway of them coming in and applying for the onshore partner visa. So if you're stuck overseas on your PMV, or if your partner is, we understand that there's going to be a mechanism to request a refund for your application fees. Now that's all well and good from a financial perspective. That's great to hear. But at the same time, that doesn't solve the problem of getting the partner to Australia. And in some sense, there's a long period there where that couple would have waited for probably 12, 24 months for that PMV to be approved, only to then be caught outside of the country due to COVID. And now I suppose the only benefit or the only pro is that they're going to be able to get their application fees back. But that doesn't solve the problem, the major problem of getting the partner into the country. Now, couples caught in that scenario or captured by that scenario may have to consider alternative options. And I would think that one possible option may be to submit an offshore 309 application. So that's the full partner visa. And for anyone who wants to understand the differences between prospective marriage visas or the full 309-100 or the onshore 82801, please attend one of our Partner Visa Secrets workshops. There's a link somewhere around this stream to go and register and save your seat. I won't go into it here because there's other things we're covering, but suffice to say that couples that are applying for their refund for their prospective marriage visa application fee, may look to apply for the 309 from offshore and then request priority processing with the offshore consulate, given the fact that they were caught out with the prospective marriage visa. Now, there's no guarantee that you're going to get priority processing, but I think these types of facts are the ones that at least have the highest likelihood of being prioritized, because certainly the scenario is very compelling. And I feel that if the offshore consulate is going to show compassion in any circumstance, it's probably going to be something like this. So I just want to say, if you or your partner are in that position, and if that's the pathway that you have to go down, it's not all doom and gloom. There is a bit of a silver lining there, in that you could apply for the alternative option, which is the 309-100, assuming that you meet the partner visa criteria for that visa type, and request priority processing. And you could, in fact, find yourself, or your partner finds himself, the 309 approved relatively quickly, which would be a more beneficial visa than the prospective marriage visa anyway. Okay, so the PMV really is just a vehicle to come into the country to then apply for the onshore 82801. If that door closes because of COVID and you're stuck overseas on the PMV and that expires, you can try the 309-100 from offshore, request priority processing, and if that all goes through, well, in some sense, that's actually been a faster pathway for you or your partner to get the longer-term partner visa, which is going to be the 309. And then eventually, they'll be eligible for their 100, which is their permanent residency. So, there may be, like I said, a silver lining to that scenario, but the main variable there is, first of all, whether or not you are eligible to apply for the 309-100. Can you show you are in a spousal or de facto relationship at the time of application? And if you don't know what that means, please again register for one of my workshops. And the second variable is whether or not you do get priority processing, because like I said, that's something we can't control. But these are the types of facts that I think could lead to priority being given to a type of case. And if that does happen, well, like I said, you've basically circumvented the need to come in on the PMV and apply for the 820, you come straight in on the 309. So, like I said, kind of good news. And that's why it's not good news, not bad news, it's somewhere in the middle. Now, the bad news, okay? I suppose what most of you here are here tonight to hear me speak about. I'll just move this so everyone can see the slide properly. The first bit of bad news is, I suppose, the confirmation or the reconfirmation that the department are going to eventually implement a change to the sponsorship approval framework. Okay, so as things stand at the moment, when you apply for an Australian partner visa, and what I might do, guys, I might draw this. This is how things are at the moment. when you apply for an Australian partner visa, you submit the visa. If you are onshore, when you submit the visa, you get your bridging visa A, which has work rights, study rights, as travel rights in the sense that you can apply for a BVB. And then, as soon as the visa is submitted, you submit the sponsorship, which is just a separate form in the IMI portal, okay? Now, the reason that this system works is mainly in scenarios where an applicant is onshore and their visa is expiring. They're on a temporary visa, and at some point in the near future, their visa is expiring, so they're planning to submit the partner visa prior to the expiration of their current visa so that they can secure the bridging visa A, which therefore keeps the applicant lawfully onshore whilst they're waiting for the partner visa to be approved. Whilst that is processing, you submit the sponsorship application form. We advise to do it immediately after submitting the visa application form. And then what happens at some point, both the visa and sponsorship are assessed. In terms of what's assessed at the sponsorship stage, there goes my pen, particularly what they're looking for is that the sponsor doesn't have a criminal history that could be a threat to the applicant. So what they're looking for are convictions and charges or relevant offenses or things that could suggest that the applicant could be in danger in future in terms of domestic violence scenarios. And that this criminal history is disclosed to the visa applicant. So the visa applicants are aware of any criminal history that an Australian sponsor has. The proposed changes will be that this is flipped, so that you have to apply for sponsorship approval first. Once the sponsorship is approved, you can then apply for the partner visa itself, okay? But this is what the system looks like at the moment. So if you submit your partner visa today, that's how it's going to be assessed. What we don't know, okay, is exactly when this is going to be implemented. Now, legislation still needs to be drafted. That takes time, okay? To give you a bit of context, these changes were initially proposed to come into effect back in April 2019. But they were postponed at that point in time, and basically things have just been put on the back burner since. Now, the announcement in the budget doesn't change what was previously announced. It's really just a reconfirmation. They're just saying we are still committed to implementing these changes, and we're going to implement them at some point in future. So they haven't really said anything new. There's been no update to what they've said previously. They haven't given us a time frame as to when we can expect the changes to come into effect. But there's still laws that need to be drafted, and that will take time. So we don't anticipate anything for several months. And I suppose the suspicion within the industry is that we could be looking at somewhere around the middle of next year. So let's say around July next year. However, that is speculation. Okay, unfortunately, I can't sit here and give you a definitive time frame because we just don't know. No one knows, okay? What exactly they will be assessing, we don't know. However, as I've shown you in this drawing, we expect it to be similar to what they already assess. Okay, so they already assess if the Australian sponsor, has, a substantial criminal history that could cause or could be a threat to the visa applicant, and that criminal history needs to be disclosed to the visa applicant. That's already assessed at the moment. The difference is, though, that it doesn't happen until later, until after the visa is applied for. The other thing that's assessed for the sponsor is whether or not they're subject to limitations. And specifically that relates to scenarios where the Australian sponsor has sponsored partners previously, or whether the sponsor themselves were sponsored for a partner visa previously. So they were previously an actual applicant for a partner visa, they were approved, they then broke up with their previous partner, now they're sponsoring their own partner for a partner visa. Those limitations already exist. The difference now, though, is that all that is assessed at the time of decision, which is a more favorable period for that to be looked at. Whereas when and if the changes come into effect, they're going to assess all that first. And this needs to be approved first before you can then apply for the partner visa. So in most scenarios, so I suppose what we can do is we can separate this between couples that are looking to apply for an offshore partner visa versus couples that are looking to apply for an onshore partner visa. If you're looking to apply for an offshore partner visa, if your partner doesn't have this type of criminal history, whenever these changes come into effect, it really has no effect on you. The couples that will eventually be most affected in future are, like I said, specifically in the scenario where an applicant is onshore and their visa is expiring and they need to apply for sponsorship approval, and we don't know how long the sponsorship approval process will take. And that's the third thing that we don't know, is how long will it take for a sponsorship approval to be granted, to be decided. Because we may find ourselves in the position where an applicant and their partner has applied for sponsorship approval and the applicant's temporary visa is expiring, but they can't apply for the partner visa because they're still waiting for the sponsor's approval to come through. Okay, so in terms of who eventually is going to be the most affected, it's going to be couples in that scenario. However, like I said, guys, it's not anything that we expect is going to happen overnight. So it's not something that you need to factor into your decision making right away. It's just something that we know will happen eventually. Unfortunately, like I said, I can't say specifically when, but all kind of indicators suggest somewhere around the middle of next year. The other thing we don't know specifically is whether or not there's going to be a cost to apply for the sponsorship application separately. When we look at, let's say, other visa types where there is a similar sponsorship application process, so where there needs to be a sponsorship approved first, and particularly or specifically I'm talking about temporary parent visas, so there's newish temporary parent visas that require a sponsorship approval first, there is a fee associated to that, and that's around $420. So we can assume that perhaps it might be in line with that cost, but again, we just don't know. But I would have to assume that there's going to be a cost associated because it's going to require man time, department case officer man time, female time to make these decisions. Therefore, the government's going to want to charge you for the time that they invest in making that assessment. So the practical effect of these changes when they come into effect is a switch in the order in how you submit applications and when they're assessed, okay? So there will be a switch that happens at some point in future, but that is not right now, okay? As things stand right now, it is as it has always been, in that you can submit the visa. As soon as you submit the visa, you then submit the sponsorship form, and then eventually they're going to assess both things together. To the next bit of bad news, okay? English language testing to be introduced for applicants and permanent resident sponsors, okay? So we understand that there's going to be English language requirements introduced for the applicants and their sponsors to, and in inverted commas, in quote marks, enhance social cohesion and economic participation outcomes, whatever that may mean. The practical effect of this is that partner visa applicants may require certain levels of English, okay? Applicants and sponsors, certain levels of English in order to have their permanent stage partner visa approved, okay? Now, when that was initially announced, that, I suppose, caused the greatest amount of panic within the industry and within the migrant sector. You know, any time the government starts throwing, the terms English testing, people start to panic. However, thankfully, the Honourable Alan Tudge, the Acting Minister for Immigration, provided a clarification statement today where he said a few things, okay? And reading between the lines of his statement, we can start to interpret and extract some key pieces of information that will help us determine or get clarification on a lot of unknowns, okay? So specifically, his statement was, from late 2021, new partner visa applicants and permanent resident sponsors will be required to have functional levels of English or to demonstrate that they have made reasonable efforts to learn English. People will be able to demonstrate this through, for example, the completion of 500 hours of free English language classes through the Adult Migration English Program. Most partner visas are a provisional visa for 2 years before becoming eligible for a permanent visa. The requirement will have to be met at the time of granting the permanent visa. While the ability to speak multiple languages is a great asset for an individual and for Australia, a person will struggle to fully participate in our society and democracy without basic English. These new measures will provide further opportunity for migrants and new citizens to maximise their opportunities in Australia. Further details about these measures will be announced in the coming months. Okay, so let's break this down. From late 2021, so that gives us a time frame indicator. It's not now, it's not tomorrow. We understand it's going to be late 2021. Specifically, he mentions new partner visa applicants. So to me and to us here at Salvo Migration, we had to look through this, and I suppose we've tried to interpret it as objectively as possible. We understand new applications to mean not if you've already submitted. So if you already have an application for a partner visa in the queue, then you will not be subject to these changes when and if they come into effect. Okay, so it's for new applicants after the changes are implemented. And permanent resident sponsors, so if your sponsor is a permanent resident now, but can obtain their citizenship or has already applied for their citizenship, if they are a citizen in future, then that won't apply to them. Okay, so it's only permanent resident sponsors, not citizen sponsors, will be required to have functional levels of English. In terms of functional, or what it means to have functional levels of English, for anyone that's familiar with the IELTS exam, which is, I suppose, one of the more common types of English language testing, or an accepted form of English language testing by the Australian government, it's a very basic level of English. I suppose what they're looking at, it's 4.5 out of 9, I believe, in English writing, reading, and speaking. So if you sit that test, if you score 4.5 out of 9, you have functional English. However, in other areas of immigration law, functional English also allows you to demonstrate that you have functional English in other ways, such as if you've completed qualifications. So if you've come here and studied and you've completed certain qualifications, that might be enough already to show functional English, and in which case you don't need to worry about sitting the English exam. Also, it's very common for applicants from certain countries, if you hold passport from certain countries such as the UK, Canada, the US, New Zealand, etc., you typically already are assumed to have functional English, and you are typically exempt from needing functional English in other visa types. So we would assume that they're going to apply a similar approach to the definition of functional English and any exceptions to this requirement. Then we have, the requirement will have to be met at the time of granting the permanent visa. Okay, so guys, when and if this comes into effect, as Mr. Tudge suggests, in late 2021, it's not going to apply at that point when you submit an application. It's going to apply specifically later when you or your partner are eligible for the approval of their permanent stage application. So it doesn't mean you need to have functional English, or the applicant's going to need to have functional English, or the sponsor's going to need to have functional English when the visa is submitted. It's going to be something that's going to be required later down the line when the time comes to approve the permanent stage partner visa. Now, by then, both the applicant and sponsor probably would have lived in Australia for another 1 to 2 years, have access to this free English classes. By then, there really shouldn't be any problems in applicants and sponsors meeting this very basic level of English from what we understand, okay? So first of all, it's not happening tomorrow, it's later next year. So most of you here probably will not be affected, because by then you would have very likely submitted your applications. When it does come into effect, the level of English that needs to be shown will not be something that you need to provide at the time of application. It's going to be something that's going to be assessed later down the line, many years down the line. By then, it's likely that the applicant and sponsor will have improved their levels of English if they've resided in Australia, and should be able to demonstrate functional English. If not, there's going to be free English classes available. And what remains to be seen, something I didn't include in the slides, is whether or not there's what we call a buyout option. So in other visa types where they have this functional English requirement, there is often a way to buy your way around it. So if you don't have functional English, you can pay an additional visa application charge to the Australian government, and they are very forgiving of the fact you don't have functional English and they still approve you the visa as long as you meet all other criteria. We don't know if this buyout will apply to this, to this requirement. That remains to be seen. But I would the cynic, the skeptic in me has to assume that I think the government's going to want to try to extract as much as they can, and I'm assuming that there's going to be that option at some point in the future. So what should we do? You and your partner, what should you be doing now? What should you do now, knowing everything that I've just taught you, everything that I've just explained, okay? First of all, don't panic. Don't panic. There's no suggestion any of these changes are going to be implemented immediately, okay? All the language, everything that we know so far suggests we're looking at July 2021 onwards. It always takes time for the government to draft these changes, draft the laws that are in line with what their policy decisions are. It's one thing for the government to announce things to the media and publicly. It's another thing for them to then sit down and draft the regulation and the legislation that's needed to actually enforce what they've said they're going to do. Okay, that naturally takes time. Don't be pressured. Okay, inevitably, in my experience, having been in this industry for 10 years, whenever there's these types of announcements, inevitably, some agencies, not all, maybe not even most, but some agencies may try to scare you into making a decision immediately. I suppose, quoting that there's uncertainty, we don't know exactly when things are going to happen, it's best just to apply now, just so it's in and that's not going to affect you, etc., etc. I mean, I'm not saying I don't agree with some of those points, but I suppose what I'm trying to say is don't be pressured into making these decisions. You now know as much as the entire legal industry does, okay? So the decision to submit and prepare and submit a partner visa application is something that needs to be considered very carefully, because what we do know is that time of application criteria has not changed. So when you submit a partner visa application, what they're looking at is what's happening at the time of application. And this is, I suppose my third point is don't rush, get your ducks in a row. Now, some of you may never have heard that phrase, get your ducks in a row. It's starting to get a bit of movement in this group. I'm hearing that people are talking about it with their grandmothers when they're discussing them preparing their partner visa. And basically, the phrase means to make sure you have your facts, your relationship facts, and your relationship documentation behind you before you submit an application. Because it doesn't necessarily matter what you do post-application, unless we're talking about the prospective marriage visa, which is slightly different. But if we're talking about the onshore 2801 or the offshore 39100, what matters is time of application criteria. And this is something I talk about at length at the workshop, so please attend. But getting your ducks in a row before you submit the application increases the likelihood of an approval. So what we know is that nothing's changed in terms of time of application assessment or criteria for a partner visa. So don't rush, get your ducks in a row. Okay, everything else is speculative. We don't know when these changes are going to happen, but we do know that if you apply too prematurely, if your facts are not strong enough, if your evidence is not in line, at the time of application, you may not meet the requirements of the partner visa. And I'd rather you wait to submit the application rather than apply prematurely unnecessarily. Which brings me to my fourth point. Please attend one of the workshops, okay? In the workshop, I'll teach you everything you need to know about Australian partner visa criteria, and I'll also show you how to do it without needing an immigration agent or lawyer, which may sound completely counterproductive to us being an agency, but I promise it all makes sense for people that do attend, okay? And it's completely free, it's 100% online. There's really no reason for you not to attend, and I promise it's worth attending. Anyone who's attended the workshop and who's enjoyed the workshop, please leave a comment in this thread, giving some feedback. I appreciate the comments that people have given me privately. I've received emails and messages of people letting me know that they enjoyed the workshop. So if anyone has attended, feel free to leave a comment in this thread, letting others know, if you think it's worth it. And fifthly, if you're the type of couple that prefers the peace of mind or just wants the peace of mind of myself, Mandy and Rachel, our legal team here at Salvo Migration, looking after your case and being on hand to take action should any changes happen. I'm not saying they're going to, but if they do happen sooner than expected, if you want us to be there, to manage that process for you, first step is to book a call with myself personally. We can have a Zoom call, we can have a telephone call, we can have a WhatsApp call, and we'll talk about your scenario, your facts, and we'll put a plan in place, looking to apply for a partner visa in future. It's not something we look to apply immediately. It's something we prepare progressively. And that's consistent with what I've been trying to tell you tonight is not to rush, okay? Despite what we've heard, that the budget announcements, there's still no need to rush into submitting applications. So the purpose of these calls is not for me to pressure you or rush you into submitting anything. It's for me to understand more about your facts, for me to give you my advice in terms of what partner visa is probably going to work best, and a time frame of when you should be looking to apply and when we can look to apply for you, if you are the type of couple that want us to do it for you. If you're the type of couple that think you prefer to DIY your application, then please attend one of the workshops. Okay guys, that is my presentation for tonight, covering what we know so far about the proposed changes. I suppose hopefully separating fact from fiction or truth from rumor. You now have the most up-to-date available information. Okay, there's really nothing else out there that's going to be more up-to-date than what I've just given you, because we spent all day extracting all the resources and making sure that before I presented we had the most up-to-date info to give you. So what I'll do is I'll jump to the questions and I will try to work through them. I'm going to assume that maybe some of them were answered as I was presenting. So if I feel that your question was already answered, I may just skip it, just given that there's so many that's been asked. I'll just quickly address Sham. Sham, yes, this video will be available, just to be clear, every week when I go live and I answer questions. So most weeks, it's not me here giving a presentation, it's me actually just answering questions. But obviously we had to kind of refine a little bit given the topic. But all previous weeks, and of course tonight as well, are available, always available, inside this group in the Units tab. So the replay of tonight's stream will be available permanently inside the Units tab of this group. We will also be posting this to our YouTube channel because there's a lot of people that don't have Facebook, that don't know how to use Facebook groups. So we will be putting a copy of this stream onto the YouTube channel as well. Kiss and Bettina. Hey man, many thanks for this. Question about priority for regional areas. If we both live abroad, how will they decide our priority? My partner is an Australian national and we both live in London, planning on moving back after the grant of the visa. He used to live in Sydney and we would want to move back there, but do we have to declare this? Another question about IELTS. Do you happen to know which test and when will be necessary? Is it for the sponsor and applicant? Okay, so I think that some of these questions were answered in the presentation. Kiss, and what I'll quickly say, I suppose the part that I will answer is where you need to be living. I mean, if you're both overseas in London, you're not living in, the sponsor is not living in a regional area. So I suppose for offshore partner visa applicants, where both the sponsor and applicant are living overseas, there's not going to be an option to have the partner visa prioritized on the basis of this regional concession. Okay, so it's only in scenarios where the sponsor, from what we understand, lives in a regional area. So unfortunately, London is not an Australian regional area. It's not a question. Looking great, mate. Keep this style as the usual one. Look, I went with the tie because it was a bit more of a formal presentation. Normally, I try to keep these a little bit more informal. Just I suppose you guys get to know me personally rather than me sitting here as a lawyer talking to you, but I appreciate the compliment. Wayne, hi Martin, we submitted partner visa application and the sponsor application. Do you think the changes will apply to us? No, Wayne, they will not. Based on what we understand, neither of the proposed IELTS or sponsorship framework changes will apply to you guys given you've already submitted. If my slide said 500,000, that was certainly a typo. It's 50,000, guys. I wish the department would grant 500,000 partner visas in the program year. That would definitely clear out the backlog and we'd see partner visas approved in a couple of weeks. But unfortunately, it's not 500,000. It's 50,000. That's been moved up to what we understand going to be around 72,000. Anna, another question. I've read on the ABC News that the immigration minister said the IELTS testing will start from the middle of next year for PMV. Anna, in terms of the acting immigration minister's media release that was released earlier today, and I think that's what a lot of the ABC article was based on. So don't worry about what the article says. Worry about what the minister's media release says specifically, because that comes directly from him, or at least his office. There's no suggestion that it applies to PMV because from what we understand, it's only going to apply to the permanent stage application. So a prospective marriage visa is not a permanent stage application. It's an initial application. It's a first stage application. Once that's approved, the applicant comes on shore. They then apply for the 82801. That's still not when IELTS would be required, according to what the media release said. It's once the 820 is approved, and then later, when the time comes to have their permanent stage approved, which we understand is 2 years typically from the application, that's when it's going to be required for the applicant and permanent resident sponsor to show they have functional English at that point. So there's nothing that suggests prospective marriage visa applicants at any stage are going to need to show functional English, or their sponsors. Samantha, evening, man. Any thoughts on how the sponsorship approval changes would mean if the applicant wanted to apply for the 600 tourist visa, then onshore, genuine intentions to come temporarily? That's a very good question, Sam. I think that if anything, it's, I hope that you've all heard me, a lot of you would have heard me speak previously about that when you apply for tourist visas with the intention of eventually applying for an onshore partner visa, that the government know that in most scenarios, the person's going to want to come in and apply for an onshore partner visa, especially at the moment with the travel exemption process that needs to apply for separately, where the relationship needs to be declared. I think that there's really little use in pretending that an applicant for a visitor visa only intends to stay temporarily. And I've spoken previously about government policy where they can still approve temporary visitor visas, these subclass 600s, even if there's a declared intention to apply for an onshore partner visa. So Sam, I think that if anything, it's going to force people to, I suppose, apply within that vein along that type of approach, because then everything's consistent. You're applying for the subclass 600. It's by then the sponsor might have a pending application to be approved as a sponsor, whereas if you apply for the sponsorship approval and then try to apply for a visitor visa and say, well, they're only going to come temporarily, to me, that's going to be contradictory to the fact that they have a pending sponsorship approval application for a partner visa. I think, if anything, like I said, it's going to increase the appeal of submitting the visitor visa with the declared intention of applying for the partner visa, because then that is consistent with the fact there's a pending sponsorship approval, and there may still be the need separately to apply for the travel exemption if the borders haven't reopened by then anyway. Gina, will a bridging visa still be granted if the process is flipped? Gina, the only time a bridging visa is granted is once the visa is submitted. So if the process is switched or flipped and we need to apply for the sponsorship approval first, then there's no bridging visa unless the government surprise us with a complete overhaul of bridging visa framework, but assuming that they don't, and I don't think that they will, if sponsors are applying for the sponsorship and we're kind of waiting for an approval, there's no bridging visa associated to a sponsorship application. So only once this is approved and then the applicant applies is the bridging visa granted. And that's why I said couples that are going to be most affected in future are going to be couples that are onshore that are waiting for these sponsorship approvals to be decided and the applicant's visa is expiring. Kerry, so it's kind of like them not raising the cost of the PR to adding a new sponsorship fee. Yeah, well, look, like I said, I don't know if they're going to necessarily impose a sponsorship application fee. I'm going to assume that they will. I think it's pretty much guaranteed. However, that doesn't mean that they're not also separately going to increase visa application charges on the 1st of July next year, which, I suppose historically has always been the case. Before COVID and before, I suppose, everything just went nuts. Traditionally, each financial year, the cost of visa applications went up, incrementally. And I can tell you, since I've been doing this, 10 years ago, the cost to apply for a partner visa back then, from memory, was I think a couple of thousand, and now it's close to 8. So it's gone up exponentially, and it's been periodically every year. Every financial year, there's typically been a slight increase. So just because they impose this sponsorship application process and the associated assumed fee for that, doesn't mean that they won't separately increase the visa application fee as well. So we could find ourselves in a scenario where at some point next year, there's the introduction of the sponsorship changes, the fee associated to the sponsorship changes, and an increase to the visa application fee. That could possibly increase the total overall cost by several $100s. I would say somewhere around the total $700 to $1,000 increase if you kind of factor in all the potential increases. But again, I don't know specifically, but that's my educated guess based on my experience, having seen these types of changes in the past for different visa types. George, hi Martin Salvo. I applied for my fiance visa, the 300 on June, and we are planning to get married overseas. I want to convert to the 309. What should I do? George, first thing you should do, attend the workshop that I keep talking about. There's a link around this stream to attend the workshop, just so that you understand what the criteria is of the 309, because it's not just about getting married, it's about the full aspects of your relationship, showing that you are in a married relationship. The second thing you will need to do is, if you do get married, is you have to notify the offshore post, the consulate or embassy that's assessing that application that you are married, and they will then convert it to the 309. Okay, so there isn't too much to that process aside from letting them know. Anna, can a B2 level international language exam be used to meet the language requirements? If I already have this, is it possible that I will be exempt from the IELTS requirement? And I can't be sure if that specifically will be, an acceptable form of showing functional English. Like I said, though, this requirement around functional English is something that's not going to be in place for quite a while, understanding that's going to be at the permanent stage application process. But we just don't know what specifically they mean by functional English for the purposes of this visa application, okay? In other areas of law, there are more than one way to show functional English. It's not just IELTS. They do accept alternative tests like PT, etc. But there's even more flexible arrangements in scenarios where you've completed qualifications in Australia and sometimes overseas as well. So, I can't say definitively, but what I'm trying to say is there's going to be more, or potentially more, than just needing an IELTS test. There might be more than one way that applicants and their sponsors, their permanent resident sponsors, will be able to meet this requirement. Love Mendoza, she's just quickly said, she said IELTS expired for 2 years. I suppose, Love, we don't know I suppose, what the validity period will be for an IELTS test. We don't know how old an IELTS test will be permitted to be in order to still be accepted to show functional English. In other areas of law, 12 months is typically still acceptable. So if you sit an IELTS test and you need to show functional English for an Australian visa application, then in certain visa types, as long as the IELTS test is less than 12 months old, that's sufficient. But we don't know if that's going to be applied across to the partner visa assessment as well. Molly, will they accept PT? I don't know yet. I assume so. Like I said, based on other areas of law that has definitions of functional English, PT is typically accepted, but I can't be sure at this point. Claudia, sounds like they just want more money, especially because of the buyout. Maybe. Not my words, but we can all interpret. I'll leave that to everyone, to have their own opinion. Abhay, if I and my partner complete 500 hours of English language classes individually, will that mean we won't have to give an IELTS exam? From what we understand, Abhay, yes. If you complete the required minimum amount of English classes, it seems that will be sufficient to show functional English, or that you've made a reasonable attempt to obtain functional English. Those were the words or the language used by Mr. Tudge. In that it may not just be about showing functional English, it may be that you have at least attempted to obtain functional English by completing the required hours of English classes. But we won't know until we see the laws. And like I said, guys, we don't, the laws haven't been written yet, so we don't know specifically. Not a question, but some of our workshop attendees have graciously given their comments. Martin's workshop is very useful. Having attended one myself, I strongly recommend it. Double exclamation marks. Thank you, Wayne. Joe, do the workshop. It is extremely valuable. You won't find this type of information elsewhere. Thank you, Joe. Parush, hello Parush. Hi guys, the course, i.e. the workshop, is totally worth it for all types of partner visas. It gives you a full understanding of the process and requirements. I strongly recommend it. Thank you, Parush. Many more comments about the workshop. I won't put them all on screen because people aren't here necessarily to learn about the workshop, but I do appreciate everyone's comments. Brenda, hi Martin. So does this mean that if I go with a tourist visa for applying from inside A20, will there still be this option of applying regarding to the weight of the sponsorship approval waiting time? I'm just going to read that one more time, Brenda. Hi, Martin. So does this mean that if I go with a tourist visa to come to Australia to apply for the A20, will there still be this option? Yes. And I suppose projecting in future, that's probably going to be this, a very interesting scenario in terms of competing timelines. So in future, when these sponsorship changes come in, there's going to be many people that will plan to come in on a tourist visa to apply for an onshore partner visa. So there's going to be a couple of options here. They can apply for the sponsorship approval first, okay? So they apply for the sponsorship approval, then apply for the tourist visa. Now the problem is that if the sponsors applied for the sponsorship approval, depending on what that process looks like, depending on what the form looks like, it's going to, I assume, require the details of the eventual partner. Now, if there's a pending sponsorship application and then someone's applied for a tourist visa, as Samantha's question earlier alluded to, is could that cause a case officer to refuse a visitor visa because they don't believe that this visitor visa applicant is coming into state temporarily because they're applying for a tourist visa. Traditionally for tourist visas, you need to show you intend to stay temporarily, but at the same time, there is a sponsorship application submitted with the government that most likely names that applicant with an Australian partner. So that's going to be a potential scenario for many people in future. And like I said, there's an avenue to be very open about the intention to apply for a partner visa, because to me that's going to be more in line with the fact that there is a pending sponsorship approval, and also there might also be a travel exemption application that needs to be submitted separately. And like I said before, you need to prove your relationship for the travel exemption anyway. So Brenda, yes, that pathway will still exist, but there's going to be potential complications there in terms of, which way do we approach this. The alternative might be to just apply for the tourist visa first, so don't apply for the sponsorship, wait until that is approved and decided. You then come in on the tourist visa, or the tourist visa holder comes in, then they apply for the sponsorship approval once the tourist visa holder is safely in the country. Then though, we're dealing with timelines, because on the one hand, the tourist visa is going to be expiring at some point that will have a certain validity period. We don't know exactly how long it's going to be granted for any tourist visa. If we're talking about ETAs and e-visitors, they're 3 months on each entry. But if we're talking about the manual subclass 600, that could be a few weeks. It could be months. It could be 6 months, 12 months. We don't know how long is going to be granted, or the permission to stay in the country is given on a 600. So it could be that someone's given 3 months on their entry validity on their 600. Then they apply for the sponsorship approval. Then we wait, because we don't know what's going to happen first, because we don't know how long sponsorship applications are going to take. Could very well be a scenario where someone's here on the tourist visa, that's 3 months in validity, but maybe sponsorship approval processes are taking longer than 3 months. What do we do in that scenario? It's not going to be a pretty picture. The tourist visa holder is going to have to find a way to extend their stay in the country whilst they're waiting for the sponsorship process. That could be messy in trying to secure a way to stay in the country whilst they're waiting. People are going to apply for extensions of their tourist visa. It's going to cause another reassessment of whether that person still intends to stay temporarily, or will the government still be lenient, that second tourist visa. These are all questions that remain unanswered, Brenda. But yes, that process will still be open. We just don't know exactly what that's going to look like just yet, okay? Because there's a lot of variables in that type of scenario. And to me, those are the people that are most at risk by the changes. The people that are coming in on very short-term temporary visas, and we don't know how long the sponsorship process is going to take. Just working through the comments. Okay, this is a relevant question. Ahmed, hi man, I really appreciate you taking the time to explain this. I feel a bit calmer now. I have 2 questions to ask. My first question is, what does the new federal budget announcement mean for prospective marriage visa application that is lodged but not yet processed? So I suppose what I'm going to do is I'm going to classify people that are in that bracket, Ahmed, that the PMV has been lodged but has not been decided, and couples that have not yet submitted their prospective marriage visas or are looking to submit in future. Now, if you are in either of those scenarios, really, the budget announcement doesn't affect those cases. It certainly doesn't affect cases that are pending. So if the prospective marriage visa has been submitted, that means that if the sponsorship framework is implemented tomorrow, that case is not going to be impacted because that's already been submitted. If we're talking about prospective marriage visa applicants that haven't submitted yet, if the sponsorship changes come in tomorrow, then yes, they're affected, but so is everyone else. Okay, so really, PMV applicants or those that have pending PMVs aren't really affected by the announcements. It's primarily people that will apply for partner visas in future. People that will apply for partner visas, from what we understand, probably from July onwards next year. I suppose the thing to understand specifically about prospective marriage visas, and this has nothing to do with the budget, it's more to do with the travel exemption and the border closures, is that if the government are providing an avenue for PMV visa holders to obtain a refund, then to me that tells me that they don't expect PMVs to be processed quickly at the moment, because they're not going to be approving PMVs at the moment if in future they need to refund the fees again. So I think what we can expect is possibly an expected delay in the decision of prospective marriage visas. But in all honesty, that has been the case since COVID, because since COVID, we know that prospective marriage visas have not been decided because they're not exempt from the travel exemptions. So the government have been approving PNVs because then PNV visa holders would separately need to apply for travel exemptions, and they're the ones that are finding these problems in trying to come in, and that's why the government are offering this refund in future. So PNVs are kind of not really caught by any of the budget announcements. It's mainly that things haven't really changed from when COVID happened, and PNVs have been put on hold. They're still on hold. It doesn't mean they can't be submitted. It doesn't mean they're not going to be approved in future. It just means that from what we can expect, they're not going to be approved at the moment until international movement goes back to something like what it was before. My second question is, how likely will the new rules on English language requirements affect the current PNV applications? It shouldn't at all, Ahmed. Like I said, the suggested or the proposed language requirements are only, from what we understand, for the permanent stage applications, which are not part of the PNV process. That happens after the PNV. It happens, several years after the PNV. Not a question, just another nice bit of feedback about the workshop. You will learn a lot from the workshop, so I'm encouraging everyone to join. Thank you, Jennifer. Tamandra, hi man, thanks for the clear info. One question, not related to the budget announcement, but that's okay, happy to answer it. If the Australian sponsor has HEX help debt, is this an issue for the sponsorship application? No, Tamandra, it's not. It's been something that was asked of me earlier this week as well. It's not an issue. It's just something that we like to declare as part of the sponsorship application form, just so that it's comprehensively answered, or that question specifically on the sponsorship form is comprehensively answered. But the sponsorship is not going to be refused on the basis that the sponsor has a HEX or help debt. Okay, so no problems there. Just declare it so the government have it there on file. Celeste, thank you very much for your presentation. I wish I knew you earlier so that I could engage you to be our agent. That's all right, Celeste. Just tell your friends. Russell, your slideshow shows 500,000 to 72,000. Is that a typo? Yes, that's a typo, guys. Okay, there's a question from Jing. It's just not letting me put it on the screen. I'll just read it out loud. Hi, man. Regarding the sponsorship assessment, filing a BVA to BVB, will it not be possible then until result is out for assessment? Jing, so unless there's a partner visa submitted, there's no BVA associated. So unless there's an onshore partner visa submitted, there's no BVA associated. So applying for a sponsorship application will not have a BVA associated. Like I said, unless the government give us a little bit of a present and in some way change the regulations to issue bridging visas in situations where someone's submitted a sponsorship application for a partner visa. But I just don't expect that to happen. So if there's a sponsorship submitted, there's no BVA. It's only once that's approved, you then apply for the partner visa. That's when the BVA is issued. That's when you can then apply for BVBs. Annie, I'm an Australian stuck overseas in Greece with my partner. Do I apply for a visit visa to get him to Australia and then apply for the A20 visa on shore? We've been living together for 3 months as spouse, but know each other for a year online. Annie, there's 2 things that I want you to do, okay? Firstly, as others have suggested, please register and attend one of the workshops. Secondly, there is an episode or a video on YouTube, one of our Partner Visa Secrets videos. It specifically talks about the options for couples that are overseas and separated by distance, and even couples onshore, understanding COVID, understanding the border closures and the travel exemptions, and the options. okay? I think it's episode 5 or 6. I think it's called Implications of COVID, partner visas, something along those lines. Just please have a look at YouTube, type in partner visa secrets, and have a look at that episode. It goes for about 45 minutes, and I talk about what the options are for people like yourself, Annie, or couples like yourself that are stuck overseas, that want to get back to Australia, that are looking to come onshore for a visitor visa and apply for the onshore partner visa. Yes, it's possible, but there's many things you have to factor in there, and there's certain risks associated. So please have a look at that episode on YouTube. But I'll just quickly say that it is possible. However, there's the things you have to factor in. The second thing is, like I said, please register for the workshop. That's where I talk about the partner visa criteria and being able to show that you are in a de facto or spousal relationship at the time of application. So that's where we talk about length of the relationship, living together, pooling finances. So that's a separate kind of requirement. That's arguably more important that you understand that first. Once you understand what's going to be required of you and your partner to meet the criteria, then you can worry about what's going to be the best option for you. So step 1, attend one of the workshops. Step 2, find that video on YouTube and get a good understanding of everything. I'm not laughing at this comment. I'm laughing at the next one. I don't know if it's appropriate for the screen, but I'm tempted. Gender. I'm an Australian citizen and I'm engaged to a woman from the Netherlands. We met online in August 2019. We met here in Australia February 2020. Okay, so met online August 2019 and then met in Australia 2020. She went back to the Netherlands July 2020. Now we're engaged. White Tuesday, I will have submitted our civil partnership application. Okay, so you're going to register the relationship as a civil union, as a civil partnership. I think that's what you mean, gender. I guess all I need now is where the hell do I go from here, mate? I'm getting a huge compensation payout within a month, so I'll certainly hire you as help to get my beautiful wife to be here in Australia so we can live for the rest of our lives here. Gender, the first thing I want you to do, again, as I've said, please attend one of the workshops, mate. That really is the best first step. In all reality, and just to be clear, anyone who leaves an inquiry with our office, that goes to our website and leaves an inquiry and wants information about partner visas, the first thing I suggest is attend one of the workshops. It really is just great foundational information that every couple really should know before they start making any plans about anything. And the sooner a couple attend one of the workshops, the better prepared they're going to be in future. And ultimately, the better likelihood they're going to have that partner visa approved, because they're going to be organized well in advance. They're going to have their ducks in a row earlier, okay? So gender, that's the first step, mate. Please attend one of the workshops. Couples that attend the workshop, are presented with different offers, and one of them is, booking a call with me and saving money on our professional fees. So even if you're a couple that, you're looking for an agent or lawyer to prepare the application for you, you want to deal with myself and Mandy and Rachel, attending the workshop is not just for couples that want to DIY. It is, I suppose, geared in that direction, but all couples will benefit, even those that want to engage us. And I can tell you that many couples that have attended the workshop have then chosen to engage us because of what they've learned, okay? So that's the first step, gender, okay? If you have any questions from there, feel free to reach out, okay? So first step, workshop. Second step, ask me your questions. Sham Patil, mate, your comment is classic. It's actually not letting me put it on the screen. So I don't know if that's Facebook censorship, but I appreciate the comment. Lydia, hi Mark. Me and my partner lived together from March 2019 to October 2019 in Canada with proof of rental. After October 2019, we were traveling together at all times, visiting my family, until COVID hit and we moved back to his parents' home in Adelaide in March 2020 until now October. Proof of paying rent to her. Do we need to register the relationship? Lydia, you need to register the relationship if you can't satisfy the 12-month rule. Okay, so legally, you don't have to register relationships. Okay, it's not a compulsory requirement for an Australian partner visa. What is a compulsory requirement is that when the visa is submitted at the time of application, you are in a de facto relationship. Now, if you are not in a registered relationship, then de facto couples also need to show they were de facto 12 months prior to that. So if you're looking to apply for the partner visa, let's say in November, okay? Let's say November this year, November 2020 this year, you're looking to apply for the partner visa and you're not registered, then you need to show your de facto now, or then, November I should say, but also 12 months prior, so November 2019. At that point, you had already lived together for 6 months with a rental agreement in Canada. Okay, so from October, so from March to October 2019, you lived together. So, to me, that suggests that it's certainly possible for you to show that around November or October 2019, you were in a de facto relationship. But we would need to know what else you had. Were you pulling your finances back then? How much earlier did you meet? So when did you meet? How long were you boyfriend, girlfriend for? How long did you live together for? Then we can start to identify if you were de facto back then or not. So it's not just about living together with a rental agreement. It depends on many other factors. Again, Lydia, please attend one of the workshops where we talk about the definition of de facto in very, comprehensive kind of teaching style. What I will say though is that unfortunately you can't register the relationship in South Australia. I mean, you can, from what I understand, there are civil union applications submitted, but it's not recognized for the purposes of waiving the 12-month rule. Only relationships registered in New South Wales, Queensland, Victoria, ACT and Tasmania are exempt from the 12-month rule. So unless you can register the relationship in one of those states or territories, and that's not going to be open to you, and if that's the case, you're going to need to prove the 12-month rule. But to get an understanding of what the 12-month rule means, like I said, there is a video on YouTube where I talk about it, but the workshop we go into it in more detail. So basically in the workshop, you'll learn what de facto means. You then just basically have to apply that 12 months before you apply. Were you de facto back then? Fred Racer. Fred, it's not letting me put your question on the screen, mate, but you've asked, were there any hints to price increase for the application? No, there weren't, but I suppose the industry speculation is that there will be. We have to assume the government are going to take all measures to recoup all the money they've been spending over the last 6 months. And migrants, and particularly partner visas, are one avenue for them to do that. So we do expect visa application fee increases. We don't know by how much, we don't know when exactly, but historically it's been the 1st of July every year. Radhika, hi Man, thanks for taking the pressure off. Regarding the PMV, can this technically be grouped within a partner visa context in terms of processing times, or is it just strictly a family stream and unrelated to a partner visa? Radhika, I suppose it depends what you mean by grouped and what definitions we're talking about here, but PMVs are partner visa. They are under the partner visa stream, and partner visas fall under the family stream. So we have family, we have partner, and under partner we have 820, 820, 309 prospective marriage visa. In terms of the language around prioritization and the increase in allocation of positions, that should include prospective marriage visa applications because they are under the umbrella of partner visas. The problem is that separately to the budget announcement, like I said before, prospective marriage visas are affected at the moment due to just kind of a global pausing in grants because of the travel exemptions, not because of anything else. So, Radhika, yes, if COVID wasn't a thing and prospective marriage visas were being approved as normal, then we would expect prospective marriage visa applications to also benefit from this increased allocation and from this prioritization of regionally based sponsors. I hope that's what your question was. Feel free to kind of ask again if I've misinterpreted. Elena, hi man, thank you for all the information tonight. If I applied for the applicant visa first and then my partner applied for the sponsor visa 2 weeks later at the time of application, will that be too much of a gap? No. No problem there. We advise to submit the sponsorship form, immediately after submitting the visa form so that it's done. So you don't forget and it's done. In all reality, though, it's very common for us to see and hear of people getting requests from the department for them to submit their sponsorship, because if for whatever reason it's missed by a lot of DIY applicants that submit their visa application but don't know they need to submit a sponsorship application form separately, and in those scenarios it tends to be requested by the department. So, and even those are approved, assuming they meet all other criteria, okay? So therefore it doesn't matter necessarily when the sponsorship form is submitted, just as long as it is submitted, so there's no problem that there's been a 2-week gap. I uploaded my partner's police check that he got from his workplace, and now I realize is a mistake. Do you think immigration will mind it? I suppose it depends on what the mistake is that you're referring to, Elena. If there's an incorrect name on the clearance, that might need to be clarified. If it's just the wrong type of police clearance, nothing to worry about. They'll just ignore it. So I suppose it really depends what you mean. But if you just mean that you've attached the wrong type of clearance, don't worry. You can just organize the correct type of clearance and upload that document. Jessa, I feel like I'm a teammate of Salvo Migration and we're doing a monthly huddle. I love the promptness of responding to this update. Thanks, man. Thank you, Jessa. It was, I'm not going to say spur of the moment, but we made the decision, in all honesty, this morning to kind of dedicate tonight's stream to talking about the budget. We were always scheduled to do a Q&A on Thursday because we do it every Thursday. But given, I suppose, the recency of the announcement, and given that there was up-to-date kind of statements given by Mr. Tudge this morning, at least we had some things of substance to present. Whereas kind of early yesterday, there was still a lot of uncertainty and confusion around what these changes were. So it all just kind of lined up that we had things to talk about tonight that I was able to kind of present confidently, knowing that there's things that we know and there's just some things that we don't know, but at least I know what those things are. Whereas before, yesterday we didn't really know anything. So things have been moving quite quickly, as you can tell. Laura, my apologies if this has been said. I've missed the first part of the video. I know the cost of the partner visa increases every July, and apparently it did not this year. That's correct. That's been our experience. That's it's what I've noticed. Typically it's every July, and it didn't happen this year because of COVID. Is it due to increase soon, or will it be July 2021? There's no suggestion that they're going to increase the visa application fee now or soon, but we expect that it will be increased on the 1st of July next year, but that's not confirmed. Okay, that's just, I suppose, our assumption based on previous trends and understanding that the government's going to try to go back to the way they used to increase visa application charges. Gender. My fiance speaks perfect English and she's a registered nurse. Depending on a few things, that might be sufficient for her to show she has functional English when the time comes for her to show it, okay? Now, I think before you mentioned if you're looking to apply for a PMV, if that's the visa type that you go down, the English language requirement's not going to be relevant to you guys for a very long time, okay? And by then, we'll know exactly what it means to show functional English. Sometimes, like I said, people that hold certain qualifications might already be exempt. We'll see. I mean, we'll see what the regulations say, what the exemptions are. But if she speaks good English and if she has, a professional qualification, then that means she's going to meet the language requirements. Whether that means sitting the test, paying the fee for the test and completing the test, she will pass the requirement based on what you said. Shem, my friend holds a permanent 189 visa, got married in February 2020, and is planning to apply for the spouse visa on or before the 20th of February 2021. Will these rules apply to his application? Shem, I hope what's become clearer throughout tonight's presentation is that we don't know definitively when these changes will come into effect, but particularly in terms of the language requirement, that's not something that's not scheduled until, according to Mr. Tudge, middle or late next year. In terms of the sponsorship changes, we don't expect that to be anytime soon. We still think that's many, many months away. The expectation or the suspicion in the industry that it might be around July next year. So if that is what happens, if your friend applies by February next year, then he should not be affected by the changes. Rahat, hello man, just wanted to confirm when you say the current applications won't be affected, does that mean people who have applied for the A20 early this year won't be affected either? Yes, from what we understand, the changes will only be applied to new applications made after the changes are implemented. So not applications that are already in the pipeline or have already been submitted, including 820 applications. Grace, you mentioned not to rush with partner visas, but that is different for PNVs. Can you clarify? Yes, I can. The main difference between applying for a prospective marriage visa and, let's say, applying for the offshore 309 or the onshore 820 is that the relationship, the facts of the relationship, the need for you to show you have an intention to marry, which is the requirement for the PNV, is assessed at the time of decision. So that's the main difference, really a key difference between the PNV and the other two visa types, where they look at the relationship at the time of application. So what were the facts when those visas were submitted? Even if the visa takes 2 years to process, case officers will go back, figuratively speaking, and look at the facts of the case, the evidence of the case, when those visas were submitted to determine if at the time of application, couples were in a de facto or spousal relationship. For prospective marriage visas, you need to show there is a genuine intention to marry, but that is looked at the time of decision, not what was happening at the time of application. So that's a big difference there, because if PNVs are going to take 1 to 2 years to process, you have that entire processing period to continue to strengthen your intention to marry evidence, your wedding planning, communication with suppliers, you booking venues, etc., showing your wedding invitations. So there's plenty of time to strengthen a PNV case whilst it's processing. So that's the difference. That's what I meant by, that you shouldn't rush into the others because they're going to assess your relationship strictly at when the visa is submitted, compared to the PNV where they look at really what was happening or is happening when it's opened. Okay, so that's the difference, and that's something I talk about during the workshop. Sheva, is Gold Coast a regional area? For certain definitions, yes, Gold Coast is considered regional. Whether or not Gold Coast is considered regional for the purposes of this prioritization of partner visas, we don't know yet. Okay, we will know more hopefully soon. Sorry guys, I'm just working through the questions. There's some that I can't add to the screen. Shoma, hi Martin, we submitted the PNV last year, but now we are planning to get married due to the 309 and switch to the 309. Does this mean we would lose the year we waited? Shoma, there's no way for me to know exactly what the effects are going to be to the application if you change. There's no way for anyone to really predict the internal impact of an application that's switched from a PNV to the 309, whether or not that means your application is kind of put back in the queue or whether it's just assessed immediately. Unfortunately, I can't answer that question. I feel that the most appropriate source to obtain that answer and to try to get a bit of clarification is to contact the consulate or embassy that is assessing that case specifically and ask them for their position. How will they approach that scenario? And whether or not it's going to negatively impact the waiting time of your application. I'm sorry that I can't give you a more definitive answer, but that is, waiting times, generally speaking, are things that no lawyer or agent can really comment on sometimes. Andrea. Hi, Man. I have a question application once submitted. When uploading our evidence, where should we upload financial or social evidence? As there is no separate category for these criteria, should it go under relationship evidence? As long as naming it correctly, thank you very much. Andrea, look, what we say is what matters more is how you rename your documentation. Renaming documents really is going to, you have more room in renaming your documentation. You can be more specific, so you can convey more information by renaming a document versus what classification or category you are uploading that document under in the EMIS system. So, where you upload it in the EMIS systems doesn't necessarily make a big difference. How you rename your document makes more of a difference because the case officer can very quickly identify what that document is. In terms of giving you some direction now, yes, uploading it under relationship evidence would be perfectly fine because that is exactly what it is. It's relationship evidence, and then you're just specifying what type of relationship evidence it is by renaming it accordingly. Purush has asked, I can't put his question on the screen, Harman, what effect will have the PMVs which will be lodged in the next month? There's no changes to the PMV like I mentioned. The main implication to PMVs at the moment are just the travel bans. Okay, but realistically, if you apply for a PMV tomorrow or next month, even without COVID, that was always going to take 12 or 24 months. By then, we hope that the travel bans and the border has reopened, and by then we hope that PMV visa grants or holders will be able to enter the country freely. By then, though, we might see that there is the implementation to the sponsorship framework. And by then, when PMV visa holders come in looking to apply for the 82801, there might be a requirement for the sponsorship to be submitted separately. That is one, I suppose, technicality we don't know yet. We don't know if there's going to be an exception to couples that already had PMVs approved to needing this sponsorship approval for the subsequent 82801 that's applied for later. Once the PMV is approved, person comes in on shore, looks to apply for the 82801. Whether or not in that scenario they're going to need sponsorship approval, we don't know. That might be something that's drafted in terms of an exception, but we don't know. Okay, we'll know more soon, hopefully. In terms of the English language requirement, so those are really the two main changes. The English language requirement, we understand, could affect those types of applicants. Again, unless there is some exception drafted in the laws that excludes people that had a pending prospective marriage visa when these English language requirements came into effect. So they may draft the laws in a way that says, if you already had a pending prospective marriage visa, then later, if you go to apply for an 82801 after your PMV is approved, you are exempt from needing to apply for sponsorship approval for the 82801, or you are exempt from you needing to have functional English and your Australian permanent resident sponsor needing to have functional English. That may or may not happen. Okay, we'll know more soon, hopefully, Purush, but that's, I suppose, understanding the possibilities of which way the laws may go. Demet, Martin, how is COVID impacting partner visas? And do you have tips for partner visa applying for travel exemption where the partner is on a TPV 405 and partner is offshore? Dermot, in terms of how COVID is affecting partner visas, really the most comprehensive answer I can give you is contained in the Partner Visa Secrets episodes on YouTube. It's called COVID, Implications to COVID on Partner Visa Options. I think it's episode 5 or 6, like I mentioned earlier tonight. Mate, that video goes for 45 minutes. I talk about all the implications in that video. In terms of tips for applying for a travel exemption, really isn't any specific tips to someone that holds a 405. The general tip is that you need to be able to prove the relationship really just as if you were applying for the partner visa itself. That seems to be what's required to get travel exemptions approved, but unfortunately they're very unpredictable. So starting point, Dermot, please go to YouTube, check out that video. Hopefully that will give you clarity on what the implications are of COVID to partner visas. Thaddy, is IELTS exam going to be required or just attending the free English classes without exams? Fadi, we don't know the specifics, but from what we understand, I suppose reading between the lines, like I said, interpreting Mr. Tudge's media release today, I think that the laws are going to be something along the lines of, you need to be able to show functional English. Here's a list of ways you can do that. Provide an IELTS exam that shows you have 4.5 average. Show that you've completed a qualification in Australia that was lasted, a diploma level qualification or more, etc., etc. So there'll be a list of ways. Or show that you've made a reasonable attempt to acquire functional English. There'll be a definition of what that means, and that's probably going to be something along the lines of, you attended or have confirmation, evidence that you attended 500 hours of English classes. That seems to be the language that was used, and that to me indicates what the laws might be in future. So Fadi, to answer your question, I'm speculating, but I'm going to assume a little bit of a bold prediction that there's going to be two ways. You either show functional English, or you show you tried to get functional English by completing the required minimum hours of English classes without an assessment. Okay, so this is the assessment stuff. This is you made a genuine attempt, a reasonable effort, a reasonable attempt. Russell, is Perth and Darwin classified as regional area? It depends on what we're talking about, Russell. There isn't kind of a universal definition of regional area when it comes to Australian immigration. It really depends on the visa type you're talking about. So every visa, just so people understand how the laws work, okay? There's different visas. Every visa has its requirements, okay? Has its requirements. The requirements specify definitions. So visa 1 may say something in relation to regional Australia, and visa 2 may say something in relation to regional Australia. But the definition of regional Australia for visa 1 may not be the same definition of regional Australia for visa 2. So therefore, there isn't a universal definition, okay? So we don't know what regions or areas or postcodes are going to be regional for the partner visa, and specifically in terms of this prioritization of partner visas. My assumption, my prediction, Russell, is that Darwin will be classified as regional. I mean, there's nothing to suggest it won't be. In every other kind of definition it is. Perth is actually a bit of a tricky one. In some situations, Perth doesn't classify itself as regional. It hasn't wanted to be classified as regional in terms of the WA government. But whether or not it is actually classified as regional for this purpose, we don't know yet, mate. Hopefully we'll know soon. Dilpreet, hi man, it's been 22 months since I applied. If they approve soon, will they grant the 820 and 801 or just the 820? Dilpreet, I don't know what they're going to grant you, my friend. I can say that I suppose our client cases typically, recently, we're finding that most are getting both approved together. So they're approving the 820 and the 801 if it's been more than 24 months since the applications were submitted. But we're also finding that even cases that are decided before the 2-year mark are still getting both stages approved. My advice to you, Dilpreet, is make sure you're updating your relationship evidence. Make sure they have up-to-date documentation to assess you on. In terms of your relationship being more than 3 years old, I know what you're referring to. That's not how it works. You need to show you are in a de facto or spousal relationship for 3 years prior to application in order to have, I suppose, a greater likelihood of the application being, or the permanent stage application being approved when they decide you. So just because your relationship has been 3 years now doesn't apply in this context. What can apply though is that because it's been more than 2 years or you're getting close to the 2-year mark, you have a good chance of the 801 being approved based on what we're finding, okay? But I can't guarantee because I don't know what your documents say, okay? So just make sure you update your relationship evidence. Levi, hi man, I'm the sponsor. I'm currently staying outside of Melbourne due to the lockdown and my partner being stuck overseas in a family-owned property, which is regional. But we rent still in Melbourne, and since our lease is ending, if I keep staying here, can I use this as evidence that I'm living regionally? There is also no rental agreement though. I'm just going to reread that. But if we still rent in Melbourne, Levi, I can't really say because I don't know what's classified as regional yet. So I can't say if you're living outside of Melbourne whether or not that's going to be classified as regional specifically, and I don't know what's going to be required to prove that someone lives regional in terms of how long does someone need to have lived in that regional area, what's going to be required to prove they live in that regional area. Just to clarify, if your partner's overseas in a regional area, that's not what this means. It's about being in the sponsor being in a regional area. So it's just you specifically, Levi, not where the applicant is, okay? But if you are living in a regional area, then that might be sufficient to get the application prioritized. But like I said, we don't know what is classified as regional yet, and we don't know what the requirement's going to be, and we don't know what the process is going to be. How do you prove that the sponsor lives in a regional area? Do you need to fill out a form? Do you need to just submit documentation? How long does the sponsor need to live in that regional area? So we don't know, Levi. Hopefully we'll know more soon. Okay, guys, I will try to answer a few more, and then we will have to wrap it up for tonight. Thank you to everyone who's attended tonight, and I hope it's been beneficial for everyone. Hi, Man, thanks for all the help you have been providing for all of us. So far, I've got most of our ducks in a row. Good to hear. And planning to lodge the 820. The 820. Not the 802, the 820. My wife is pregnant. Congratulations on her second 462, and it expires next March. I'm an Australian citizen and our child will be born next month. Would it be better to lodge before the child is born? As I've read that having a child on a working holiday visa is in breach of the visa, but we haven't seen that condition on her current visa conditions. That's a very common question. I would need to have a look at her visa conditions in order to be able to answer that question in terms of complications for her working holiday visa. However, in terms of applying for the partner visa, if you are expecting the birth of a child, then to me that tells me a lot about the nature of the relationship. As long as you're showing that you're cohabitating, if you've gone so far as to register the relationship, as long as you've pooled your finances, I feel that maybe waiting until March next year is an unnecessary amount of time to wait to apply for the partner visa. In terms of having a child and the implications to a working holiday visa, that does fall a little bit outside of our area of expertise, such as we don't prepare working holiday visas. We don't deal with applications to working holiday visas specifically. But I can tell you though that having a child of the relationship will only strengthen the partner visa itself. You don't necessarily need to wait for the child to be born in order to apply for the partner visa. The child is born an Australian citizen because you are an Australian permanent resident or an Australian citizen sponsor. It's not like they're attached to her working holiday visa. I've never personally heard of a working holiday visa being cancelled just because someone's had a child. I think that's a bit of a rumor. So, look, I can answer part of that question, Satrup. I can't answer all of it. Kelly O'Neill, what's the point of having offshore partner visas if they just want everyone to apply for a tourist visa, then bridging visa, then onshore, which makes no sense? Kelly, the offshore partner visas are still being approved. The only offshore partner visa type that's not being currently approved, are the prospective marriage visas. But we still have the offshore 309-100s being approved, and I can tell you that our own client cases are being approved, and I'm seeing others in the industry get their client cases approved as well, the offshore 309-100. So it's not that the government aren't enticing people to come in and apply onshore. That's not what they're saying necessarily. They're just saying that we will prioritize certain applications where the Australian sponsor lives in a regional area, and that with the border closures and the travel exemption process, the prospective marriage visa holders are not exempt automatically. They need to apply for travel exemption separately. PNV visa holders that are caught overseas, they can't come and their visas expire, will be able to apply for a refund. So just to clarify, Kelly, the offshore partner visa kind of framework still exists. So people can still apply for offshore partner visas. So it's not so much about the budget, it's just about understanding that everything's affected by COVID, and particularly couples that are overseas. I mean, there's practical implications to even being able to travel at the moment. So in certain scenarios, some couples are just deciding to apply for the offshore 309-100, get it in, get it submitted, know that it's in the queue, and then move on with their lives and continue living overseas, wherever that might be, whilst they wait for that visa to be approved eventually. Whereas some couples that are overseas are deciding to try to come onshore, try to apply for a visitor visa, try to apply for a travel exemption, try to find flights, deal with the quarantine requirements and costs to come onshore, to then apply for the onshore partner visa. That's what they're electing to do, but that's not being forced on them by the government. As I've said to others, there's a video that I talk about all of this on YouTube. It's one of the Partner Visa Secrets episodes. Please check it out. Hopefully it's going to clarify really what the options are, Kelly. Mick, hi man, I'm applying for a partner visa for my partner is offshore. The cost is around 10K for my wife and her daughter. If for any reason the applicant is rejected, is there a refund component? Mick, only under very, very specific circumstances will the government refund a visa application charge. Typically, in the event that the Australian sponsor passes away, during the processing or waiting of an application, will the government give a refund for a partner visa? But if the partner visa is refused simply because it was poorly prepared, or the evidence was not sufficiently collected, or the relationship wasn't sufficiently evidenced, and they don't accept that the couple are in a de facto or spousal relationship, or if it's a PMV that they have an intention to marry, they're not going to refund your fees. It's just that the government have made a discretionary, arbitrary decision on your relationship facts, and that is partner visa assessment. That is partner visa criteria. That's why I suggest everyone to attend one of the workshops, because you learn about what those requirements are in a lot more detail. So simple answer, Mick, no, there's no refund component just because it's refused for normal reasons. If it's because of kind of a reason beyond, the applicant's control, and it's something along the lines of the partner passing away during processing, then yes, there is, typically an avenue to apply for a refund. Okay, a couple more, guys. Hi man, we're looking forward to lodge our A2001 in March 2021, which is when my training visa 407 runs out. My question is, in the unfortunate event that these changes are implemented before then, and the preliminary sponsorship approval takes time beyond March, is there a possibility of getting a bridging visa on the grounds that I will be waiting an outcome of the sponsorship approval? Mambo, that's a very nicely and well-worded question, but it has been something that I've kind of answered previously. And I suppose just to reiterate, unless the government change the laws in how bridging visas are issued, then applying for a sponsorship approval will not entitle someone to apply for a bridging visa a BVA, which is the bridging visa you want. Only in scenarios where you apply for a partner visa onshore is a bridging visa legally applied for, in most cases, okay? So unless there's a change and the government are lenient because they understand that people might find themselves in that type of scenario, we don't expect bridging visas to be issued to people just because their partner has a pending sponsorship application. I think there's going to be many, many people that are caught out where they're going to need to apply for a visa to extend their stay, such as a visitor visa, and that has possible implications, because what happens if the visitor visa is refused? What happens if it's approved with a condition that doesn't allow them to apply for another visa? A lot of variables. I think there's just going to be a lot of pain in future for people, unfortunately. But we just, we'll have to wait and see exactly what that looks like, Mumbo. But to answer your question, no, I don't expect that there's going to be a way for you to apply for a bridging visa just because you've applied for a sponsorship approval or your partner has and your visa is expiring. Unfortunately. So now, hi man, I really appreciate your efforts helping people get their partner visa applications done. I am a 3-9 visa holder which was granted in January 2020, and the question is, do I need to appear for my English test when applying for the 100? I applied for my 3-9 100 in November 2018. So now, from reading the acting minister's, Mr. Tudge's, the Honourable Mr. Tudge's media announcement today, we understand that only new applications from next year will be subject to this requirement to prove English when the time comes for them. So based on the language used in the statement today, we do not expect people like yourself to need to show functional English, or your partner if they're a permanent resident, given you've already applied for the visa. So even if the changes are implemented tomorrow, based on the language used by the minister, we don't expect already submitted applications to be affected. It's only going to be new applications after the changes are implemented. Okay, guys, I'm just going to pick one more randomly, and then I'll have to wrap it up for tonight. I'm sorry I just can't get through to everyone. There's just a lot of questions. Okay. Annie, hi man. I'm an Australian stuck in Greece, no flights back as my flight was cancelled. And yes, that's a very common scenario, unfortunately. I want to return with my partner, but he's Greek. And what is the best way to get him into Australia with a visitor visa so we can apply onshore for day 20? I suffer from anxiety, difficult to fly back alone. Please help. I have 3 children in Australia. Annie, look, I have to check the visitor visa eligibility for Greek passport holders, but just to explain, there's only 3 visa types, temporary visa types, visitor visa types that are granted to Australia. The e-visitor, the ETA, and the subclass 600. From what we understand, with COVID, the ETAs are not being processed. So you can apply for the e-visitor if Greek passport holders are eligible to apply for the e-visitor. I can't give you that off the top of my head. I'd have to have a look. But it's either you're applying for the e-visitor or the subclass 600. Whether you do either of those, though, you separately need to apply for a travel exemption for your partner. And again, that's something that I talk about at length in our Partner Visa Secrets YouTube episode. Please go have a look at that first, okay? But that is the first option, is apply for a visitor visa of some kind. Either it's the e-visitor, if Greek passport holders are eligible, and the travel exemption. When you apply for the travel exemption, you prove your relationship to the department and you try to get both approved. If both are approved, then you jump to the next hurdle, which is, as you've already experienced, trying to find flights to come to Australia. And even if you find flights, not getting bumped off the flights because of this cap in terms of how many people the Australian government are permitting to enter the country on any given day, which is influenced by many factors, how many COVID cases there are domestically, internationally. So a lot of variables there, unfortunately. If you get those approved, you find flights, you come on shore, you deal with the self-quarantine requirements and the cost, then you apply for the onshore partner visa, Annie. That really is all the hoops and hurdles that need to be jumped through. Unfortunately, if you and your partner are looking to apply for an onshore partner visa, really now and for the foreseeable short term, given that there's just no expectation that that's going to change really anytime soon. We don't know exactly when things are going to go back to normal. We don't know what normal is going to be whenever that happens. We all just have to adapt to the scenarios and the requirements at the moment. Step 1, Annie, please have a look at that YouTube episode. Like I said, it covers everything I just mentioned, but in more detail. It's got some slides there. So if you enjoyed tonight's presentation, that's basically the same way that I teach that presentation, okay? So I think that's going to be the last question. I might answer one more. Okay, last question. Gender. Hi, man. My fiance lives in the Netherlands. We met in August. She flew out. I think I answered this one, but I might just keep going. We lived together for 3 months. She was actually granted a BVE, but she had to go back for personal reasons. She speaks perfect English. She is a registered nurse. We are engaged. What would you suggest I do? Give you a call or go to a workshop? And where are your workshops and when? Okay, gender. Workshops are hosted Monday, Tuesday, Wednesday, Friday, Saturday, Sunday nights, so not Thursday nights. They're online. There's a link to register around this stream. That's the first thing. So don't worry about doing anything else. Just go and attend one of the workshops. After the workshop, you'll be provided links to book a call with myself if you want us to assist you with that application process, okay? So that's the first step for you, Gender. Go hop on one of the workshops, book a call after that, okay? I'll answer one more question because that wasn't really a question. Charlotte, is there a different visa if you get married onshore, or do you still need to apply for a de facto partner visa? Is there a different visa if you get married onshore, or do you still need to apply for a de facto partner visa? Okay, Charlotte, so there's only 3 partner visas. So Australian partner visas, where the Australian is a permanent resident or an Australian citizen, there's only 3 types of visas. There's the offshore 309-100, the offshore prospective marriage visa, and the onshore 820-801. When I say 820-801 and I say 309-100, I mean they're combined applications. They're 2 together. Okay, so whether you get married in Australia or out of Australia makes no difference to the visa options. So it doesn't matter if you get married in Brazil or if you get married in Melbourne. You still have the same partner visa options available to you. So in this scenario, if you get married onshore, you're looking to apply for the onshore 820-801. But you're not applying under the grounds of de facto, you're applying under the grounds of spouse. So 820-801s and 309-100s, only couples that are in spousal relationships or married relationships or de facto relationships are eligible. Not boyfriend-girlfriends, not boyfriend-boyfriend or girlfriend-girlfriends, okay? It's spousal or de facto couples are eligible for the approval of those visas. So Charlotte, as I've said to everyone, please attend one of the workshops. I talk about those definitions at length, and I promise you it's all going to make much more sense. Okay, everybody, thank you very much for attending tonight. My apologies if I haven't been able to get to your question. There's been a large demand for my attention tonight given what was covered. I hope, though, that if I wasn't able to get to your question, that at the very least you've been able to learn from what was presented and from listening me answer other people's questions. If people still have questions, you're more than welcome to post separately in the group as a separate post, not in this thread, but in a separate post. And we will try to get to them throughout the week. Otherwise, I'm sure other members will provide their opinions, and perhaps those that have attended tonight will be able to give you answers as well. So that's it from me, guys. Thank you once again. I hope that this gives you all some clarity and reduces your anxiety and stress levels, and that you understand that things aren't as bad as perhaps it was initially thought, and that we don't expect things to really happen anytime soon. There's still time. We don't expect the majority of these changes to come into effect until middle of next year, if not longer. However, at the end of the day, we just don't know exactly when these things are going to happen. So there's a few links around the stream for, booking a time with me if you want to speak to me, or attending one of the workshops if you want to learn more generally about partner visa criteria. That's it from me. Thank you once again, Martin Salvo.